There's a very interesting High Court case supposed to start there on Thursday of this week. It's the dispute between the billionaire John Magnier and the Barron estate down in Tipperary. And the dispute has to do with the sale of that property. John Magnier claimed that he had a deal to purchase the property, and the Barron estate, the owners of the Barron estate, denied that there was a deal and sold the property to somebody else for a significantly higher sum of money. The judge, though, and a few days prior to the case commencing on Thursday, has ordered legal representatives for the owners of the Barron estate to explain how they interpreted the discovery documents or the discovery requests for documents which were being sought by John Magnier's legal team. So as part of any High Court case, litigation case like this, there's a discovery process, and the discovery means that you have to discover or share with the other side relevant documents that are relevant to the actual trial, to the actual dispute. And in this case, there was an order for discovery made, but the order for discovery made reference to communications. And the High Court judge is now asking the legal team for the Barron estate to explain how they interpreted the particular request for discovery, because lawyers acting for Mr. Magnier in his action against the owners of the 751-acre farm outside Clonmel in Tipperary, they have concerns that relevant documents have not been disclosed to them in advance of a scheduled 3-week hearing, which is supposed to start this Thursday. Mr. Magnier wants to enforce a deal that he claims he did for the purchase of the estate for 15 million euros. He says that the deal was struck with the owners of the estate in August 2023 at a meeting at Mr. Magnier's Coolmore Stud in Tipperary. The defendants, the owners of the estate, denied that there was ever any such agreement, and subsequently agreed to sell the estate to a man in the United States, Maurice Regan. He's the construction millionaire or billionaire, and they sold to him for 22.5 million euros. So the deal with Magnier was purportedly for, the alleged deal was for 15 million. They sold for 22.5 million. Senior counsel for Mr. Magnier told the judge on yesterday, that it had emerged that the defendants did not disclose to them a screenshot of a contemporaneous note made by John Stokes. He's a Tipperary-based estate agent, on or about the night of the August 2023 meeting. The senior counsel told the court that following a request for documents to Mr. Stokes, who was present at Coolmore Stud, they received in January the screenshot of the note that Mr. Stokes made on his mobile phone. Senior counsel for Magnier described the note as a key document because it made reference to the purported 15 million euros sale agreement and to the various terms recorded. And any memorandum or document which would record the sale of a property and the various terms recorded would be absolutely critical in enforcing the contract, in enforcing a purported contract or a claim contract. Counsel said that the note was a record of what happened at the meeting and the communications between the individuals who were present. The Barron estate side received the screenshot from Mr. Stokes in January last year, the court heard. Counsel said that the defendants provided several explanations justifying why the screenshot was not disclosed to them. One was that the note was not captured by their requests for discovery. And you might wonder why that is. But Ms. Gagan, the counsel for Magnier's side, said that if the defence's approach was not to discover the screenshot because it did not fall into the request criteria, then it was a concern that other relevant notes that may be in existence relating to the meeting had not been disclosed to them. Martin Hayden, senior counsel for the defendants, said that Mr. Magnier's lawyers specifically sought, quote, communications in their request for discovery of documents. And he said that the phone screenshot taken by Mr. Stokes, the estate agent, was not a recording of a communication. And this is the interesting legal argument. The order for discovery on the one hand said all communications had to be discovered or disclosed and shared, whereas the screenshot of a meeting, or a note rather, a screenshot or a contemporaneous screenshot on Mr. Stokes' mobile phone wasn't necessarily a communication, is the argument from the side for the Barron estate. Senior Counsel Martin Hayden said that the note was not sent by Mr. Stokes to anyone, and he said that if the document was not communicated, then it is patently not a communication. It's his own document, he said. The judge said that it was not obvious to him that the note was a record of communication between Mr. Stokes and anyone else. He refused the application for an order for discovery to be made for any contemporaneous notes prepared by key custodians relating to the alleged deal. However, the judge did order that the defendants file an affidavit explaining how they interpreted the requests for discovery of documents sent to them by the plaintiffs. The case returns to court on Thursday. It's supposed to last for up to 3 weeks. It's a very interesting case, and it has to do with the sale of land, or the purported sale of land. It has to do with the enforceability of a claimed or a purported agreement, and it's from a legal perspective and from a legal student's and indeed a legal practitioner's perspective. It's an important case. It'll be interesting to see A, what the actual evidence in the case is, and B, what the decision is at the end of it. This report is based on the reporting in the Irish Times, and the Irish Times article was written by a gentleman called Fiachra Gallagher. So Fiachra Gallagher, Irish Times, it's his reporting that I'm relying on for this video. Hope you find the video useful. If you do, would appreciate if you hit the thumbs up button down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button. Thanks a lot.